Hello everybody, my name is Jesus Martinez. I'm an attorney, and today I want to talk about Daca and marriage to a U.S. citizen or a legal permanent resident. So if you have Daca and you get married to a legal permanent resident or U.S. citizen, can you yourself become a legal permanent resident? The short answer is that it depends. If someone has Daca, there are two general ways to become a legal permanent resident. One is through consular processing, the other is through adjustment of status. In order to be able to adjust status in the US, you have to have some sort of legal entry, some sort of lawful status. For instance, if you previously entered on a student visa, if you entered on a tourist visa, that may allow you to adjust status in the US. In addition, if you also had some sort of parole, advanced parole in place because of a family member is in the military, then that may also allow you to adjust status in the US. If you don't have a lawful entry into the US or you don't have some sort of parole, then you would generally have to do consular processing, which takes place in your country of origin where you were born. The laws for adjustment of status and consular processing are the same. The big difference is just where are you going to have your interview, where are you going to do your processing with USCIS. So after determining if you're going to do consular processing or adjustment of status, there are a whole list of other laws that apply to make sure that you are admissible, that you are able to become a resident. There are far too many to list and talk about right now. For individuals that are going to do consular processing and you entered without a visa, without documents, you are here undocumented, aside from your Daca, before your Daca, you didn't have some sort of documents, immigration documents, then it may be that you need a waiver, waiving your unlawful presence. Unlawful presence begins accruing once you turn 18. And for a lot of people, they turned 18, they got their Daca when they were 20, 21. So for those individuals, they would generally need an unlawful presence waiver. For individuals that have more than 180 days or more than a year of unlawful presence, they need this waiver. Before the administration of Obama, if individuals wanted this waiver, they needed to return to their country of origin, and once there, apply for this waiver. And the process took months, close to a year. However, under the administration of Obama, the laws changed. Now individuals can apply for this waiver in the US, wait for their response, and if it's approved, then they go to their country of origin and they have their interview, and if they pass, they get the residency. And granted, if this would be the case if their only ground of inadmissibility is the unlawful presence, there may be other issues that a person doesn't know about. There may be issues that the person thinks may not be known to immigration. For these reasons, it's very important to speak with an attorney that is experienced in these matters, because a person may think that, immigration doesn't know about something, or if they don't say something, then how will immigration know? So it's imperative, it's very important to speak with an attorney. Also, for adjustment of status, the laws of inadmissibility also apply. You may need a waiver for some other ground of inadmissibility. In order to know whether you need a waiver or whether you can apply to become a resident, you should speak with an attorney, because they will be able to orient you and analyze your case and make sure that there are no reasons that should bar you, that should make USCIS reject your application. So I highly recommend speaking with an attorney. If this video was helpful, please let me know in the comments. Like, subscribe. We will be uploading more videos.